Hey, I think you got a message saying it's being live streamed. I think you succeeded, Mike.
Wasn't my pre-scheduled one, but at least I have it
Oh, it's something.
going there. All right. See how laggy we become with all of this open.
Hey, I think you got a message saying it's being live streamed.
Oops, I better.
We are going to have some delay. Mike.
Wasn't my pre-scheduled one, but at least I have it. All right, let me just test some audio here. Am I coming through okay?
Now you seem to be coming through live.
Okay.
That delay was going to be super disorienting. I tell you now. Maybe that's in case we said anything, obscene for the airways, and it would give us time to delete it. We're just not that exciting.
M29. Okay. I think I will go ahead and make us live here. And I'll do a recording. I'm going to do belt and suspenders. We'll do
Excellent.
a recording.
Very attorney-like of you, Mike.
Yeah,
That's when I learned that phrase, belt and suspenders.
I guess.
Not to law school, and I was old when I went to law school, so
there are a lot of those which I don't love anymore, because the term pursuant I always tried to avoid at all costs, because
you heard it one too many times in law school.
We're about to get underway here. I have about 5 minutes before the hour. So what else do I need to get up here? I've got Westlaw. I've got the Mata case. Anything else you want me to bring up to show?
No, I've had kind of a distracting week with a bunch of stuff due, so I wasn't on the reference desk as much. I don't have a good reference question of the week. I'm going to rely on yours and just riff on whatever you're doing. I
had mostly other work to do this week as well. I had some document automation, and I don't think I had any client work to do with legal research this week. But I jumped on this unfortunate story.
I actually, unfortunately, I actually did help one of the other reference librarians with a question that I bet you could provide a bit of insight into. So I'll pull that one out. Yeah.
Well, let's get rolling officially here. Close enough to 8 o'clock, I guess. This is the Gray Paper Pod. Each week we answer the question, what was the most interesting legal research question? I'm Mike Carlson. I'm with Gray Paper Legal.
And I'm Karen Westwood, Director of the Hennepin County Law Library.
Welcome back, everyone. We are going to talk about the most unfortunate brief ever written in lawyer history, I think. I have to say, I do feel sorry for these New York attorneys who relied on ChatGPT. I probably I don't know if I should or shouldn't. I imagine it's quite a bit of agony. As I was looking
imagine that is cascading down throughout at that firm. Who did the initial research? Who passed it on?
Yeah.
How many times did it move through with no one checking? Yeah.
But it did present some interesting legal research questions for me, because you and I have talked about how we've both gotten hallucinated cases and how we recognize those. So we'll jump into that. Karen, why don't you start? What was your most interesting legal research question of the week?
Well, we had one of these questions that is I think illustrates some issues with publishing maybe legislative changes. So an attorney was requesting several sections, annotated sections from the Uniform Probate Code, the UPC. But when you pull that up in Minnesota, for every section, on Westlaw at least, you get that section twice. And one includes the 2019 revisions. So if you go back to the beginning, so I was like, I think it's weird it's not called something else, like the revised Uniform Probate Code, if there's a different version. So we went back and did some reading, at the beginning of the section of the Uniform Probate Code that indicated in 2019 there were some clerical adjustments made. I think similar to how in Minnesota in 1984 they changed all the gendered language in all the statutes.
Oh,
I think they were technical changes like that. The problem is not so much then that the content of the code is different. It's that those two versions have a different number of annotations. So which one do you provide to the patron? We ended up providing both, but that's just a lot to slog through. So it's I think it's a little bit problematic. When there's a significant change, of course, then you want to provide the version of the statute that was cited to or that you plan to use. But in this case, we couldn't figure out which version of the UPC to send. So I'm pretty sure we just sent both.
Were you looking at the Westlaw version or
Westlaw,
the Westlaw version? Okay.
Yeah, because the patron wanted annotations.
Gotcha. That makes sense. I've seen that on do you happen to recall the section?
Gosh, I don't, but I think the whole UPC was received these technical changes. So I'm pretty sure we'll get it for most.
For most of them? Okay, I'm just going to grab, let's see, let's do 2-206.
And then I'll find out that only one section received.
Yeah. I have seen it in annotated statutes where there are just so many annotations that you get double. So when you run a find or when you just run the citation to bring up the document,
right,
it'll come up twice. And the reason for that is there are just so many annotations. You get the citation twice. It's the same document, but
I think this wasn't so many citations. It was like, one version had 68 and one had 72 or whatever.
Yeah.
It was unclear. So I'm sorry I didn't prepare this better because it looks like it's not the case on this one.
When it's in the hundreds, oftentimes.
Well, You know what though? I think it wasn't in Minnesota statutes annotated. I think he was in the uniform laws.
Oh, just the uniform law. Let's see if that's
I'm pretty sure that's what the patron was asking for because we were having the conversation. Well, which jurisdiction, is the patron looking for? But apparently she just wanted. So
that makes sense. Yeah, if you're looking at the uniform law, you're probably looking at multiple versions. Let's see.
Right.
Random one. Who may make a will?
Yeah, and I think maybe I think maybe you just have to search it UPC 2-501 to pull up the two versions because now we're just within that one version, the 2019 amendments.
Oh, I see what you're saying.
What I mean?
Yeah.
Search is going to make a difference. I think. Let's see. Here, drum roll, please. Sometimes recreating the problem is a bigger problem.
There you go. Yep. Exactly.
So you have these multiple versions, which are really the same version.
And that makes sense to me that you do that because you don't necessarily know what state you care about. It's a uniform law. So if you're going to run a find to a specific section of a uniform law, you're going to want all enacted versions, whether or not they're your state's enacted version. So that,
Right.
I guess that does make sense to me.
And
That's
look at
different
that, Mike. I think it's just what you said. The numbers 2 and 3 on your list are both the 2010 revision, but there are so many citing references. Is that an instance of where they've broken that up? And then there's the 2019 amended version that has 91 citing references, but it isn't a revised version of the code. If you go to the beginning of the UPC, you see that in 2019, they made just some clerical, technical kind of changes.
Yeah, and you see that this one is bracketed here, and I think if you look at this section here, maybe the statutory text is still here.
Yep.
But yeah, I believe that's probably the case.
Yeah, look at all those notes of decisions. Yeah.
Yeah, 214. So only 181 citing references. Yeah, and I'm sorry, that's probably more accurate. Is to say it's the notes of decisions. Only 181 citing references.
Yeah.
So there are only in fact only 93 cases. But within the cases, you'll have the editors may create a note of decision, multiple notes of decisions for just a single case.
Right.
And that can get quite voluminous. And so oftentimes they'll break, just for viewability, they'll break it down into multiple results.
Yeah. So be aware, you researchers, that you may not be getting, the full universe of what you think you are. So check what those different,
they're
not additions or versions, just check all the things that pop up.
I use those regularly with statutory research, just filtering those notes of decisions, or usually I'm just browsing this item on the left, looking for my topic.
Right.
And that's very helpful. Browse, super simple research technique, right? Just looking at the list for your particular item. But that works pretty well quite often with these notes of decisions.
Right. Even when you have hundreds of them, huh?
Yeah.
It'll just really filter it down. Yep.
You can filter if you need to by date and jurisdiction, but often I'll just look for the topic that I'm interested in.
Yep. The lucid moments, testamentary capacity.
Yeah.
You got it right there.
Okay. All kinds of good stuff.
So that was my interesting, sometimes it isn't so much the research itself that provides a question, it's how to interpret the results that you get that provides the heavy lifting there in figuring out what you're doing.
Yeah, absolutely.
So that was my question, Mike.
Yeah. So, and as I said, I didn't have a ton of client work on the research end. I had mostly document automation work to do this week, but I did take a little time. Everyone's heard about the poor attorney in New York. I don't know if I feel some sympathy for this attorney who used ChatGPT. I don't know if I should. A lot of attention brought to this case here, Mata versus Avianca, where the attorney used, as everyone surely knows by now, used ChatGPT to help with a brief, found a number of cases, inserted the briefs, even there were 6 cases that the court said they couldn't find because they were hallucinated by ChatGPT, and the in response.
But they were submitted in.
Yes.
In the response. Well, what happens when you download the PDF?
Yes. So you can see, this one is not a hallucinated case. This last one here. If we open that one, this is in Court Listener, by the way, where I pulled the docket. This docket has been reviewed so many times. All these documents are available. Here's a fast case.
Yep.
So, which likely legitimate, and then the Miller versus United States. You can tell that this one was also likely generated by ChatGPT.
Oh wow! Look at the format is weird.
Yeah. This is it's a short little document, pretty brief, 2 pages from the Second Circuit Court of Appeals. Probably not likely. It's super interesting to look at some of these things, though. McLaughlin, Jacobs, and Parker, I believe, are all judges in the Second Circuit Court of Appeals.
Okay, so they found some legit judges.
Yep. And I didn't do it. We can do a docket search for this, and the party name. Likely we're not just going to come up with anything, but I thought all of this was very interesting, and we've been talking with each other and with our colleagues about how we get cases from clients, from users, from patrons who have found something on ChatGPT. In my case, it's usually a client saying, "Hey, just something to get you started."
Yeah.
Here's something that I found on ChatGPT. Sometimes they'll say it's ChatGPT. Sometimes they won't. You know, and then or later I'll get an email that says, "No, never mind. That was a hallucination."
That's so funny. Instead of it being something to get you started, they should say, "Here's something to slow you down."
Right. Right. Here's a little extra work for you.
That's right.
I thank you. I appreciate that. I charge at the 0.1. I do tenths of an hour. But it was interesting to me because I wanted to use these cases as a way to see what I could learn about how ChatGPT was generating these results. With old school natural language processing, we have some very basic ideas about how that works. And it's pretty simple and rules based. It has to do with the numerosity and the density of terms in the document, as I understand it.
Right.
And so the more words there are, and the closer they are clustered together in a document, more likely that's to be a relevant result that's placed at the top of your result list.
Right.
And we know as researchers then that we could have a very relevant term that doesn't appear within our very relevant case that doesn't include our terms, near the bottom of that result list. So we just, because we have some idea of how that is operating, we typically use natural language processing as just one strategy for conducting a search tool. We looked at Fastcase here. Fastcase has a tool. I don't know if it's still available. I haven't been in Fastcase in a while, but they used to have a tool where you could adjust the settings for the relevancy ranking.
That's right. I remember that. Yeah. One of the only vendors that let you direct how the algorithm was going to work for you. Yeah.
They had things like how often it had been viewed or printed as well. That was sort of an unpopular feature in Westlaw Next when that was released. The librarians, I won't say melted down, but they were like, the concern was that, well, if students are using this and they're not good, or unskilled researchers, and we would say, well, that's just one element in the natural search, and you can still do Boolean and whatever. So don't worry. But we didn't know to what extent. We couldn't articulate how the algorithm was working. But on Fastcase, you were able to with a slider move that up and down. I never could think of a really good reason about why you might want to.
No, but you kind of liked knowing you could do it. If you wanted to.
Right.
Yeah.
Well,
I know. I remember the librarians. We were really concerned. I was at an academic law library at the time, and the concern was if we couldn't force a Boolean search in, all we would see would be the more popular items, the ones that were viewed, which is great, right? If you're looking for Roe versus Wade, you want that to be the first one to pop up, not the thousands of cases that cite to it. So it had this merit, but we're working with professors who are trying to find some obscure case to write about. And the fear was those less popular cases would gradually just disappear and become less findable. And I think that's what a lot of law librarians were worried about. Once we were able to use Boolean searching within Westlaw Next, everyone breathed a sigh of relief. But part of that is, and what we're hearing more with ChatGPT, but which is going on all the time and has been for years, is if you don't know what the algorithm is behind behind the curtain, it's hard to know if you're finding the results that you want to, or it's hard to understand why you're getting the results you're getting. But of course, those algorithms and things are proprietary. So, I mean, ChatGPT, I guess now is open source, right?
Yeah, but what do we know about coding in any
Exactly.
meaningful way? I hope we'll take a look at some of the results here to see if we can learn anything. I don't know if my methods were very good or not. But I think the relevancy ranking and ChatGPT have sort of different kinds of problems. If I do a search for standard for motion to dismiss in federal courts anywhere, Westlaw, ChatGPT, it's going to give me Twombly and Iqbal.
Right.
It's just too present in the text universe to not deliver those results.
Right.
And the with traditional natural language processing, the risk is you're not getting a hallucinated case, but the case you want either doesn't appear or is just way too far down on a list that you're not going to be able to filter to, or it doesn't exist. So you're just missing something. That with ChatGPT, it'll be delivering something that is completely irrelevant. And I think if you just know that.
Right.
I think Bob Ambrosi made an interesting point about this case. He said this isn't even a tech competence issue.
Right.
He said this is just straight up incompetence. You read the cases that you cite in something, right?
Right.
You find them yourself and read them. You don't.
Right.
So in this case, perhaps the attorney.
I do feel though, Mike, I feel a little sympathy for this lawyer, right? Because how many people are up against a deadline and they just send something along? Everyone assumes the person before them has done something, and other people under a deadline assume the person after them is going to do it. And this was just one of those situations where no one caught it. Where in most situations, someone would have caught it. So, I mean, it's a great cautionary tale, right?
I think it's an excellent point too about working in a team. And this attorney also wasn't admitted to practice in the Southern District of New York, a federal court. So, working, with a colleague and as attorneys, among the things that we're not added to the list of things that we're not necessarily trained to do is to work in teams collaboratively.
Right.
Instead, it's much more inefficient because of our professional responsibility. We're all expected and responsible for all of that content. And that's sort of, but that's hugely inefficient.
Right.
It's not necessarily a good thing for the professional, even if it's a good thing for the profession. So yeah, I do sympathize. It is incompetent, but and I don't know, here are all the exhibits. Did the attorney, and if you read this response, it says, actually, I couldn't find a couple of these cases. So it was honest, but here are the other ones, right? Here's Peterson versus Iran Air. I don't know.
Exactly. Yep, and that Shaboon versus Egypt Air, that's one of the hallucinated ones I think I was reading about. Someone trying to figure out how that case came to be. It was elements of several other cases that then just generated kind of a made up case. Yeah.
Yes. Did you, and that's what those elements is one of the things I was just trying to figure out. I don't know if you, I'd be curious to know what you were reading about that, because that's essentially what I did to find out how ChatGPT might have fashioned those cases. And I started with party names and things like that. I thought I had here's one of my sample queries. You can let me know if this is proper methodology for this kind of research. But this is, I don't know if you can see this, but I did a search. So I was looking for the Peterson versus Iran Air case.
Right.
Peterson's a challenging one. They had a Miller in there too. You figure Peterson, easy get for the ChatGPT, just a super common white person name.
Right.
You know? And then I added in my initial searching for some of these cases on the Shabun and Varghese, which had more unique names,
Mhm.
which are case names. I was finding a lot of summary judgment, not 12b6 motions. So that was one of the things I was wondering about, is whether ChatGPT was substituting legal principles, related but distinct legal principles, right? They're
Mm.
dispositive motions, but running similar searches for 12b6 or failure to state a claim or things like that weren't giving me any results that made any sense to me.
Right.
In the summary judgment, though, some of those items seem to be making sense. So I was wondering if conceptually it was swapping similar but distinct legal issues. Don't know for sure, but that
Right.
seemed like a possible thing that was happening. So here I did Peterson with the asterisk for the many of our listeners probably are well aware of kind of what the Boolean does here, but this is like a blank Scrabble piece on Westlaw. So it'll give us the EN or the ON
Right.
synopsis digest case for that information, that stuff that the Westlaw editors add at the top, so we can find a case not just referencing summary judgment, but a case about summary judgment.
Right.
And then I did the at least restrictor, which just guarantees that we'll see a variation of the term air or airline, in this case with the root expander, at least 2 times, just to see. The idea here was, I'm thinking, it's looking for air cases. I don't know what the prompt was that the attorney used, but
Right.
I'm assuming it had something to do with airlines, because all of the returned results were too spot on, right? Egypt Air,
Right.
Ryanair, like, wow,
Yep.
those are good cases. So I just looked for that term to appear at least twice within a document, and I kept it in all state and
All
federal.
state and federal. Yep.
And this was just one of my this is one of my favorite result sets from this case. And I don't know if this is, again, proper methodology or what I learned from this, but our second result here is a Delta Airlines case, Abdu Brisson.
Mm-hmm.
When I noticed, looking at the Shabun case versus Egypt Air, I did a quick little Googling around and then found that I looked up the ethnic origin of Shabun and just Googled it, and I got some, for what it's worth, maybe nothing, a little map of the world that showed me that Shabun is as a surname that's most commonly found in Egypt.
Okay.
So I'm here I'm reading this as a Persian prefix here,
Uh-huh.
and we have a case similar. I'm guessing that it generated this result similar to the way it generated Shabun versus Egypt Air. Just assume the ethnic origin of the word.
Sure.
If ChatGPT is a word assembler, right, and if it's looking to find out what the most next logical word is, it makes sense to me that it's making assumptions about ethnicity. In this case, Peterson appears several times.
Oh,
You can
yeah.
see all of the parties listed here, and there are a ton of Petersons in this case.
A whole family there.
Yeah, the whole family. Some unfortunate circumstance here, but it was a Delta Airlines case, and I thought, maybe similar to Shabun, Peterson styled it as Peterson, but borrowed from this case. We know that, and there's kind of an interesting article written by Damian Reel.
I didn't see the Damian Reel article.
Presentation on ChatGPT.
Yeah.
It was just in Bench and Bar. It just came out.
Oh, gotcha. Okay. Yeah.
From the Minnesota Bench and Bar magazine. And he noted that, of course, the text, the LLM has been trained on legal text, statutes, and case law up until 2021. So it just, I mean, it makes sense to me logically. I don't know if this is a logical conclusion, but that it would generate this result. A Peterson versus Iran Air based on a text like this one, where there are a lot of Petersons. Airline is a subject of the case, in fact, a title of the case, and a sample case includes, a prefix like Abdu. I don't know. I tested a couple of, I think it was Dolly or Midjourney. I don't remember which one. Just visual AI searches.
Oh yeah.
I did a search, and maybe we chatted about this before. I did a search for attorney a computer, and it was 4 dudes, of course. I think one of them had a gavel, and then I did a search for paralegals at a computer, and there 4 women at a computer. There was one person in a suit with long hair. So on the one hand, you think, wow, that's, you could think that that's technically sophisticated. The model did some work to distinguish between paralegal and attorney. And how do you do that? You just have 2 legal professionals. I mean, there should be no difference, right? You have that.
How could you tell visually? Yeah.
Right. And we're not in a situation where any of these tools are saying there's nothing. That the tool is designed to deliver something, and it's going to use whatever garbage is out there in the universe, all of our biases and the assumptions are all part of that package. And so that's how you get those results, even when they're hallucinated. So I don't know. It was super interesting. I don't know, entirely what I learned from this. As you say, like with the having that fast case advanced search where you just knew or had that reminder about how the results were ranked was helpful, to just keep in mind that was one strategy that you use. You don't rely on it entirely,
right?
Or whatever your next step might be is informed by that understanding.
Right.
And so it was this exercise was interesting to me for that purpose. Maybe I don't know, whether or not I've learned anything super valuable in this exercise, or whether the assumptions.
It's really interesting, that kind of connection between names, right? And if you're going to have an Egypt airline, well, then probably you want to find a more Egyptian sounding name. It's interesting to kind of picture, what is ChatGPT trying to do? I mean, because in creative writing, right, that's super appropriate, right? You're going to, I don't know, write a fictional story that takes place in Cairo. You want to pull in some Egyptian sounding names. But in law, you don't really don't want to do that.
Yeah, and if it's Iqbal, if it's Twombly, it's an easy get, but it's not thinking, right? It's manufacturing a set of words together that makes sense based on what's available. The traditional legal research, we think about a search against a database that delivers us results. With ChatGPT, it's not search. It's a manufacture of words based on a textual corpus, which it may or may not be delivering results, may just be forming words. So it's
but I'm glad that you're exploring the development of some of these legal based uses of ChatGPT technology and those large language models, or is that what it's called? LLM, large language models?
Yes.
Yeah. Because if you have a more reliable corpus that you're building on, it could be that some of these weird hallucinations start falling away and you get material you really can work with. And that'll be very interesting to see how that develops.
And and what's nice about like co-counsel, which I've complained about as being a little expensive for what it is, though valuable. What you get, of course, is a little articulation of the point of law, a link to the case, right? And if you click on the link, you can see it actually is a case. It's coming from the case law database. So in that case,
Right.
co-counsel is doing both things. It's manufacturing the words and delivering the case law results, so you're getting both.
Right.
And which you're still having to verify the work, right, the manufactured piece. But
I was just going to say, you would still want to read those cases, but at least you have a fighting chance of finding a real case.
At least the court, in that case, the court could find them, right?
Right. And whether you agree with the interpretation of the proposition the case stands for is another thing, but at least you have the document to look at. So that'll be very interesting to watch develop.
And I do think, it was I mean, strictly speaking, that is literally a violation of comment 8 to rule 1.1, right? It's, if you're supposed to keep abreast of, then you didn't.
Well, exactly. If you use ChatGPT and then afterwards say, well, I didn't know, then right, you're directly counter to that. Rule 1.1 really to be competent, and it's specifically comment 8 to understand technology that you're using.
And just, there's a reminder here at the bottom.
Right.
Which says that may not be true.
In small print, like all those important messages in small print.
I also think there's sort of a traditional unfair, the conventional wisdom is that lawyers are slow to adopt. And, usually have their head stuck in the ground. And here we have, and this is a very generous reading of the situation. Here we have an attorney jumping into ChatGPT, trying to use it for probably the reasons you mentioned, right? Better efficiency, under the gun kind of situation. Now we're shouting it down as incompetent, which also true, but definitely a middle ground there where
exactly. I mean, and it doesn't encourage someone then to go out and try new things if you're going to make national headlines with this bench slap. Oof.
Yeah, this is
gotta hurt.
It is more than just a bench slap. I mean, there'll be that for sure, but the whole community is
A great cautionary tale, though, for people teaching legal research, right?
Yeah,
that's and all those lawyers' professional responsibility courses.
This could be you. Yeah, that's what I like. I like to scare the shit out of my students so that they. I don't know if that's an effective pedagogical.
No. I prefer to encourage students to be aspirational rather than living in fear, because that's no way to practice law. So.
All right. Well, we're at the bottom of the hour now. Thanks again, Karen. It's always fun. Is there anything coming up for you next week that I should be thinking about or preparing for?
No, my vacation is coming up, so I'm just trying to stay focused one more day here before I leave. So
yeah.
Nothing coming up. How about for you?
I have. I'm still working on the CLE. I've warmed up to the text a little bit more. I've been reading Ben Smith's The Traffic, and I've been warming up to that a little bit. I haven't found a presenter yet. We're going to do a little law and literature on that, and I'm not sure how to categorize the subject matter. This is sort of a law and type of presentation. So interested in somebody, with a journalism background or, especially online journalism.
Sure.
So if you know anybody, or if any of our listeners want to recommend a co-presenter,
Yeah.
I will buy the text of Ben Smith's text for our co-presenter and send it along. So,
Interesting. Yeah. Great. So a pure journalist, or you want a journalist who's also an attorney?
I like to have an attorney who's also got a background. It's not
Right.
critical.
Yeah.
But somebody who's got some familiarity with the subject matter,
Sure.
probably.
Yeah. Oh, that'll be interesting. Yeah. I'll think about it. Yep.
Even
Yeah.
even somebody like Guy Takalakis. I might reach out to him and Sam Conrad, see what they think about it.
Yeah.
Actually, I'm just thinking this out loud with you. I shouldn't do that.
It's great.
All right. Excellent. All right, Karen. Well, you have an excellent vacation.
Thank you.
Next week we'll be joined by an excellent substitute. And we'll see you then. And
Sounds
you
great.
Black. I don't want any interesting legal research questions from you next week.
Well, I hope not, because usually that means something went wrong if you come up with one on vacation. All right. Take care.
Take care. Bye-bye.
Bye-bye.